Hi colleagues, Scott Solkoff coming to you from Delray Beach, Florida with news about Florida's new power of attorney law that went into effect just on October 1st of 2011. So I'm going to go through with you the highlights. We've got a much more complete article and video on the website if you want more information. But this is important stuff for any attorneys that are drafting for clients who are outside of the state of Florida, attorneys who are outside of the state of Florida, drafting for clients who snowbird here or who spend any time in Florida, or of course for attorneys in Florida drafting for our Florida clients. So I'm going to go over some of the highlights of the new act. First off, the new act says that any co-attorneys, in fact, instead of requiring unanimity if there are two or a majority vote if there are three or more, now are presumed to be able to act independently and on the signature of only one attorney in fact. That's a big change in Florida law. There are new enforcement provisions. If I go to any third party, well, the biggest change in powers of attorney law prior to this one was all the way back to 1995 when that statute said that any third party must accept my power of attorney. And if they unreasonably refuse to accept that power of attorney, they have to pay my court costs, attorney's fees, and damages. Well, that gave teeth to the law, and that's still the case in Florida. The problem we were having is they were taking 3 weeks to determine whether they would honor it. So the new statute now puts a reasonableness requirement on any third parties, including these financial institutions, who now have, well, 4 days is deemed reasonable by statute as the default. It could be longer under certain circumstances and probably should be less under most circumstances. And if they refuse to honor that power of attorney, they must give their reason in writing. An interesting new feature of the statute to help protect the third parties is to say that if they want clarification, they can have the principal bring a written opinion from Florida counsel explaining that the particular act requested is valid under the power of attorney. So that's a new provision. Now, for out-of-state powers of attorney, there's a specific provision in the new Florida statute saying if you're an out-of-state attorney, you drafted a power of attorney for a client who is resident of that state at the time and now happens to be in Florida, the third party may require the principal to get an opinion of Florida counsel that this out-of-state or foreign power of attorney is valid here in Florida for the act requested. So that would always apply to out-of-state attorneys or out-of-state powers of attorney. The third party is protected if they get that letter from the principal's attorney in Florida, and if they refuse to accept it and the principal doesn't give them that letter, they're also let off the hook. Now, big change, no springing powers of attorney in Florida. So it used to be the case that I could draft a power of attorney that said that it would go into effect upon my incapacity or some later occurrence. No more. All powers of attorney in Florida are effective upon signing. Superpowers. Yes, there are superpowers and new Florida powers of attorney. We're not talking about Superman. We're talking about the ability to make changes to my estate plan if I'm the principal. Well, that's a big deal. We've had issues in Florida over what the language should be in these powers. And now the language allows us, the statute allows us to include language authorizing the attorney in fact to be able to make changes to my beneficiary designations, to be able to make changes to my trust, to even create or revoke my trust. But if I use these superpowers, I must have the attorney in fact. If I'm the attorney, there are new execution requirements. I must have the attorney in fact sign their full signature or at least their initials next to each of these provisions for these new superpowers, these abilities to modify testamentary dispositions. These new execution requirements must be complied with or they're invalid. There are new time limits and acceptance, as I said, the 4-day rule. So we have a better enforcement provision. We have more clarification in the statute. These requirements must be abided by in drafting, and so we have all new powers of attorney that we just started using this week. I hope you'll be able to use this information to help your clients better. If you want more information, call us anytime. Thank you.